Thanks for coming, everyone. I'm going to present the results of research I carried out in the later part of last year and earlier this year on youth remand trends. And before getting into that, I'll define, for those of you less familiar with youth justice, what I mean by remand, and also why we're particularly interested in remand and custodial remand in particular. I'll also talk about some of the initiatives currently happening within Oranga Tamariki. So when a young person has been arrested by police and appears in court, remand, referring to the custody and release arrangements made between each court hearing. There's 5 options available to the youth court. The young person can be released without conditions other than to appear in court when required. The young person can be bailed with specific conditions they must adhere to. They can be delivered into the custody of a named person who can be a parent, guardian, caregiver, or some other person nominated by the Chief Executive. There's detention in the custody of the Chief Executive of Oranga Tamariki, and detention in police custody where the young person will be held in police cells. So why are we interested in remand and custodial remand in particular? Well, at a very fundamental human rights perspective, there's the United Nations Convention on the Rights of Child. So that says that children under the age of 18 years should be treated differently because of their age and level of development. And Article 37 in UNCROC says that, or to paraphrase, detention of a child shall be a measure of last resort and should be used for the shortest appropriate period of time. The Oranga Tamariki Act, the principal act for dealing with children and young people who offend, has a key principle in it that young people should be kept in the community as much as possible and consonant with public safety. And finally, the expert advisory panel who reviewed the care and protection and youth justice systems and recommended a new operating model for Oranga Tamariki. In the youth justice area, they touched on the negative aspects of residential care, one of which the UN refer to as criminal contamination, mixing very young, inexperienced offenders with older, experienced offenders leads to bad future results in terms of offending. So the EAP recommended that future youth justice services should try and reduce the number of people remanded to secure youth justice residences. Just to give you a picture of the current state of our residences, we've got 4 residences around the country, 3 in the North Island, 1 in the South Island. The maximum capacity is probably in the number of people in this room, about 140 youth justice beds and 6 criminal justice beds. At the present time, 75% of those beds are occupied by young people on remand, and only 25% have been sentenced to supervision with residence. And as a point of reference, in the adult system, those figures are the other way round. 29% of adults in prison are on remand and 71% are sentenced. One of the reasons why we're particularly interested in custodial remand at the moment, you can see probably the red flashing light on the right-hand side there. 17-year-olds coming into the youth justice system from the middle of next year. At the moment, given the predictions of volumes, they aren't going to fit in that tiny gap there, and so inevitably there's going to be many 17-year-olds who will be held in youth wings of adult prisons, and I think Ashley's going to touch on that in her presentation. So after the EAP report recommended a focus on reducing custodial remand. Well, that was one of the key priority areas for Oranga Tamariki, and it's also a priority area in the Youth Crime Action Plan. So this research I'm talking about today was commissioned to inform options of ways we could reduce custodial remand, and some of the questions that I was asked to look at are listed there. It should be noted that inevitably with quantitative research you do answer a lot of questions, but you also raise a lot more questions, and this research did that, and I'll talk about some of those as I go through the presentation. To do this research, I brought together data from 3 agencies. The core data I used for the analysis was from the Ministry of Justice. It was all cases commencing in the youth court over a 5-year period, of which there were around 10,000, and so they provided information on remand decisions and offences, outcomes, etc. I also, for that cohort of 10,000 cases, I obtained data from police on offending histories, so I could look at offending while on bail, and also on bail breach incidents, so I could look at compliance with bail conditions. And then I used some of our own data to look at where people are placed when they're detained in the custody of the CE. Okay, there were many challenges with analysing this data. The core data I used was court cases, which are all of the offences or charges that are being dealt with at a point in time for a young person. And while that may sound simple, unfortunately young people re-offend, and new offences come into the picture, and the way I had to join cases was a bit convoluted, but I got there in the end. One of the things I found when looking at remands is that while 2/3 of young people stay on the same type of remand for the whole case, 1/3 had 2 or more changes in remand, and in fact there were 461 different sequences of remand that people had, including in 1% of cases there was 10 or more changes in remand. So they basically went bail, custody, bail, custody, bail, custody through their court case. The second most common remand type was bail, then custodial remand, followed by bail again, and later on I'll refer to that as remand sequencing if you're wondering what that term means. So on to some results. This shows the type of remand used at the initial court hearing for 2011-12 and 2015-16, and you can see clearly bail is used in most cases for children and young people appearing in court. However, custodial remand, the use of it has more than doubled over that 5-year period, from 5% to 11% of cases, and there's also been a small increase in youth held in police custody at the start of their court cases. You can see that Section 2381C, where the young person is delivered into the custody of a named person, is very rarely used, although most people on bail will be going home to one of those sorts of people. In my report, which you can see when it's published, I break down much of the information by gender, ethnicity, age and region, so there's an awful lot of detailed information available in the report. Too much to touch on here, but I thought I'd just talk about a couple of breakdowns, demographic breakdowns. The graph on the left shows the proportion of youth detained in custody at the initial hearing by gender, and you can see that both genders experienced a more than doubling in the use of detention and custody. And on the right hand side it shows how the seriousness or average seriousness of offendings changed, and while it's increased for both genders, there's quite a gap between male and female seriousness of offending, and it begs the question, why is the use of detention and custody so close for young males and females when there's such a large difference in their average seriousness of the offending? And it may just be the way the system is responding to quite young girls having quite complex mental health and abuse histories, and safe accommodation may well be an issue for them, but you still have to look at whether that is appropriate. This graph shows the use of detention and custody by region, and if you focus on the right-hand map for 2015-16, nationally 14% of people are remanded in custody, but you can see in counties Manukau it's double that, and 28% in Auckland City it's also very high. And while the average seriousness of offending in those regions is quite high, it's also high in other areas where there isn't such a high use of detention and custody. And you can see Tasman stands out there as 2% of cases being detained in custody, so obviously that can be done. As I mentioned, remand changes a lot for some people, so it's useful to look at all the remands in cases. And I think the key point here is the custodial remand bars. To me, it's quite amazing that in 32% of all court cases involving children and young people involved a remand in custody. And police custody, the young people being held in police cells, 11% of cases in 2015-16. I think part of that large figure was due to reduced capacity in youth justice residences in early 2016, which meant that people were held in police cells for short times until residential beds became available. So I looked at bail in more detail in this research, and data from the Ministry of Justice was available on the bail conditions that are used in cases, and on average people have around 4 bail conditions imposed, and as you can see there, they're often that they must live at a specified address, obey a curfew such as not leaving home between 7 o'clock at night and 7 a.m. in the morning, not to associate with co-offenders or contact victims, or not to consume alcohol and drugs. And there's all sorts of other bail conditions that show up around not driving, restriction on travel, not to enter specified premises, etc. And so the data from police allowed me to look at bail breaches, so how often the police recorded in their system that they detected a bail breach. And I think this is certainly something that needs attention. In the last year, 69% of all young people on bail had one or more breaches of their bail conditions. And of particular note, the green line in the graph, which shows that the proportion of youth on bail with 3 or more breaches increased to 41%, from 22 to 41%. And for me, it's hard to imagine that that's a reflection of worsening compliance by youth. It may well be a change in police practice around bail checks. I noticed in the last 2 years in the police annual report, the number of bail checks is a performance measure, with the target in 2015-16 being 330,000 bail checks across the youth and adult systems, which is 900 a day, which seems rather a lot. I looked at offending while on bail, and the majority of youth on bail don't re-offend. However, over the 5-year period, 44% did. If you look at the right-hand side of the graph, in 2015-16, 46% of youth committed an offence while on bail, and 25% of that was burglary or theft-related offences, and 8% were violent offences such as injury-causing acts or robbery. So in terms of all the offences committed while on bail, over half of them are burglary and theft, and around 18% are violent offences. So one of the questions I was asked in the research was, to what extent do bail breaches and reoffending on bail lead to the young person moving from bail to custodial remand? The two columns in this graph, the one on the left-hand side shows the extent of breaches and reoffending for those people who stayed on bail, and the column on the right shows those for the people who moved to custodial remand. And you can see that reoffending and bail breaches occurred in over half the cases, and in fact very few cases didn't involve breaches or reoffending. And while you can't make that causal link, there must be an important link there. There were 6% of cases on the right-hand side there where there didn't appear to be breaches or reoffending, so I looked at those more and in our CIRA system, and there were breaches occurred in some of those cases that weren't recorded in the police data, but there's also other things happen that lead to bail ending. For example, young people not turning up to their court appearances and going missing for extended periods of time, and also the young person's behaviour at home. They were violent towards their caregivers, etc., and it made the bail address untenable, and they ended up being remanded in custody because of that. So there were a number of questions that arose from this research around bail, which you can read there. Essentially, it boils down to whether or not the current use of bail conditions and the enforcement of bail conditions is setting young people up to fail, when in fact shouldn't they be more focused on supporting young people to be successful on bail? So the expert advisory panel recommended using secure youth justice residences less for people remanded in custody, and this graph shows where young people are placed when they're detained in the custody of the CE. The majority are placed in youth justice residences, between 60 and 70%, but you can see already we are using community placements for around a quarter of the young people on custodial remand. The challenge in that is that it's not always sustained when they're in the community. Absconding is a criminal offence, escaping lawful custody, and obviously reoffending has its consequences. So around about 1/5 of those people remanded into the community ended up being in secure residence, presumably because of absconding or reoffending. And I talked about how custodial remand isn't used very much at the start of court cases, and in fact when you look at all custodial remands, 60 to 70% of them follow the young person being on bail, and only about 20 to 30% of them are from the start of the court case. So that is kind of one of the key conclusions from this research, that while bail is used in most cases, it's not always sustained, whether it's bail breaches, offending while on bail, or other factors. Considerable numbers of youth are ending up being remanded in custody, and changing that pattern has the potential to avoid many custodial remands. I just thought I'd finish up by talking about some initiatives that are happening in Oranga Tamariki. The Evidence Centre has carried out some qualitative research into remand decision making. They observed cases in the youth court in 2 locations. They had focus groups and interviews with key stakeholders, Oranga Tamariki staff, police staff, and youth advocates. They also interviewed some young people on remand in 2 residences, and so they've collected a lot of very useful information around things like participation by youth in decision making, also key stakeholders' views around the remand decision making process and what could be improved. And so a report will be coming out later this year. One of the ways we're looking to not remand so many people into residences is there's 4 group remand homes been set up around the country. They can take up to a maximum of 18 young people in total. They use different operating models. There's a mixture of live-in caregivers and Oranga Tamariki staff, and there's also different ways that the young people can end up in the homes. And for 2 of them, at the moment, they're assessed in the residence as their suitability to go into the home. And so those different models will allow some assessment of perhaps what works best. There's a remand options investigation tool being trialled that when police oppose bail, this tool is looking to gather information from key people to inform the remand decision and hopefully help better remand decisions to be made. So that's being evaluated, the live prototyping of that's being evaluated. And finally, there's an initiative underway looking at ways to better support young people to be successful on bail. And so that's looking at a wide range of things, including do young people understand what bail means and what bail conditions means and the implications of not complying with them, making sure more bail support's available to both the young person and their family, better risk assessment around potential things that could go wrong and whether the use of bail conditions is appropriate. And that's the end of the long winding road.